let's talk about the first pillar of estate planning, which is part of the Ettinger law firm's trademarked program, the lifetime estate planning process consisting of the 4 pillars. The first pillar of estate planning is the basic plan using a revocable living trust. And that starts, the basic plan does, with a power of attorney. And power of attorney is a legal document whereby you as the client appoint someone else to handle your legal and financial affairs if you're unable to. We generally recommend that you get that power of attorney from an elder law firm like ours, because the elder law attorneys have more experience with disability, and there are additional powers that we like to add into the power of attorney so that it's more effective when you need it. So we call the power of attorney that we use actually an enhanced power of attorney. It's sort of like the difference between over-the-counter medicine and prescription strength. The reason we use the prescription strength form, some of the additional powers we found we need that general lawyers tend not to use are a power to create a trust or make a change to a trust, a power to change beneficiaries. Perhaps the beneficiary's in a nursing home. You might want to change it so it doesn't all go to the nursing home. The biggest problem with the power of attorney, and the biggest change the elder law firms like to make, is we like to add an unlimited gifting power. And what I mean by that is a standard power of attorney allows gifts up to $10,000 a year, sometimes a little more. But we find if a client has to go into nursing home, we're often looking at needing to move hundreds of thousands, especially when you consider the family home, not tens of thousands. So for the past 18 years now, we've given over 10,000 clients an unlimited gifting power. Because you can actually save hundreds of thousands of dollars if you can move it out of an ill person's name. Under Medicaid rules, it's move it or lose it. So we feel you should appoint someone in your family that you trust, or 2 of them acting together, authorize them to move as much as the law allows. Can often save at least half the assets if we can get it out of the ill person's name. And the key to getting it out is your family has to be in charge. They have to have the right to move the money in unlimited amounts. So the first estate planning document in the basic plan using a revocable living trust is the enhanced or prescription strength power of attorney that you get from the elder law firm. So you not only get the person or persons you want to handle your legal and financial affairs, but they also have all the powers they need to do whatever the law allows. Then for medical, you need the healthcare proxy and living will. Healthcare proxy is the person you choose to handle your legal and financial affairs if you're unable to. You're primary, but if the doctor certifies in your chart that you're unable to handle your affairs, then the power of the agent, the healthcare proxy, is triggered. Now the living will is the document that says if they get me hooked up to machines like feeding tubes and there's no hope of recovery, and perhaps at some point I have no meaningful existence, I would like someone in my family to be able to say when enough is enough and terminate the life support, what they sometimes call pull the plug, so that in effect I can be allowed to die with dignity. Now in New York, no one, not even your husband or wife, can pull the plug unless they can prove this is what you actually wanted, and the proof must be in writing. So either you have that paper to produce or you don't, and if you don't have it, you could be another Terry Shavo. Remember her, the woman in Florida? Mr. Shavo didn't have anything in writing, so if you recall, he wasn't able to be in charge and actually carry out his wife's wishes. Again, it has to be in writing. People, in my experience, usually choose their spouse. If they don't have a spouse, they choose an adult child. Remember now, you can only pick one person at a time. The reason for that is if you pick 2 people and they didn't agree, then the doctor wouldn't know what to do. So only one at a time for health. For financial and for legal, you can have 2 or 3 or even more people, but for medical, only one at a time. So that's the beginning of any estate plan. It has an enhanced power of attorney, preferably. It has a healthcare proxy and living will. Now let's look at the plan itself. Most people today still have a will. There are some drawbacks with wills. they have to go to court to settle being the main one. And that's perhaps the main advantage of a trust. It doesn't go to court to settle. Now, you may know the name of the proceeding to settle a will is called a probate court proceeding. And with a trust, you don't go to court. It's a different legal structure. What does that mean for you and your family? Well, common sense would tell you if you don't have to go to court, you're going to save time and you're going to save money. But common sense doesn't tell you how much time and how much money. For that, you need some legal experience. So let me share our experience with you. We get a fee of up to 1% to settle a trust. We get up to 3% to probate a will. So take the size of your estate, do the arithmetic, and you'll see that you can save tens of thousands of dollars not having to go to court to settle. There's also the time involved. Of course, common sense tells you it takes more time to go to court than if you don't have to go to court. And there's also the executor's fee. In a will, you have an executor, and executor's fees average over 3%. In a trust, you do not have an executor. You have a trustee, but trustees' fees are about 1%. So we're looking at costs maybe of a third for the trustee versus the executor. What we're seeing today, in essence, is average middle-class people saving tens of thousands of dollars, not having to go to court. And you know, that's what court fees can range today, often in the five-figure area. So you save a lot of time and you save a lot of money. The other reason we like trusts, I personally like trusts, is because I used to be a litigator, and that was the first 11 years of my career. And based on my experience as a litigator, I like to keep my clients out of court, because when you go to court, who's in charge? The judge. Now, does the judge always act in your best interest? Well, the judge has other considerations. Does a judge ever make a mistake? Well, sure. In fact, every case I lost, a judge made a mistake. But be that as it may, what is happening with a will is your family eventually is going to court and asking a perfect stranger for permission to get the assets from you. Does it sound absurd? Well, ARP said this 18 years ago. In '91, the AARP published a consumer report on probate and advised the memberships to start setting up trusts. And that actually started the living trust revolution. It's now 18 years old because we're taping this in the year 2009. And since '91, millions of people have set up the trust. And the first reason, avoid the expense and delay of a probate court proceeding after I'm gone for my loved ones. I mean, it just makes perfect sense.